Supreme Court took another copyright case, this one involving how we calculate the statute of limitations for a copyright claim. It involves a man who was incarcerated and therefore was not aware that a song was used without authorization for a sample on a Flow Rider song. And let's talk a bit about copyright and statute of limitations. The statute of limitations is the time frame in which you're permitted to bring a complaint. And once you pass that time frame, you no longer have that remedy available to you. So for instance, in a personal injury claim, we're going to measure it from the time of the injury, and once it's X amount of years past that injury, you no longer have that remedy. Now, with a fraud claim, you might not have been aware of the circumstances giving rise to your claim. So we're going to measure it by the discovery rule. When you discover the fraud, or within a reasonable diligence, you would have discovered the fraud. Now let's get to copyright. The copyright statute of limitations under the Copyright Act is 3 years from which the claim accrued. When does the claim accrue? Well, it depends whether it's a copyright infringement claim or it's a claim of copyright ownership or authorship. If it's a copyright infringement claim, we're starting that 3 years from when the infringement occurred. However, if there's a continuing infringement, you're going to get a new clock, a new life on that lawsuit. But you're only going to get damages back 3 years from when you filed the complaint. That's why many, many years after Stairway to Heaven became popular and known to the world, someone who believed that their song was ripped off to make Stairway to Heaven sued for copyright infringement, or the estate did. That was about 10 years ago. If they won, they only would have been able to get damages from 3 years behind when they filed the complaint, which means decades of millions and millions of sales of Led Zeppelin 4, they were not been able to recover for that. However, they did not win that lawsuit anyway. Now, with a copyright ownership claim, or a claim that I own this and you don't, or a claim of copyright authorship, we're setting that 3 years from when there's a refutation of your ownership or your authorship, and you don't get a new clock. The moment somebody says, I own this and you don't, or I authored this and you don't, that's when the clock is ticking. It's for this reason that parties who have been sued for copyright infringement like to turn it into a copyright ownership claim. It happened with a lawsuit over the Dimebag Darrell guitar. The creator of the guitar sued another creator of a guitar for infringement, and the potential infringers said, this is really an ownership claim, because 10 years ago, I told you that you don't own the copyright in this guitar, in the copyright, Dimebag Darrell does. And because of that, the copyright statute of limitations has ended. It was more than 3 years ago. I never agreed with that, but the 11th Circuit Court of Appeals did and ended that lawsuit. And that is also the precedent case when Neely sued Warner Chappell over the Flow Rider sample. However, it got really complicated, and I'm going to have to talk about the circumstances of that lawsuit in another edition of Copyright News.